Hello and welcome. Thanks for joining us tonight for How to Win a Family Court Motion, hosted by the DCAO, which is the Divorce Coaches Association of Ontario. At the DCAO, we're a community of divorce coaches and allied professionals such as lawyers and mediators, some of which you're going to hear from tonight, and other divorce professionals dedicated to supporting individuals and families through separation and divorce. We do this through education, advocacy, and public awareness initiatives like this workshop tonight. And DCAO works to ensure that anyone navigating divorce, including those without legal representation, has access to the support they need. So tonight, you're going to hear from two of DCAO's leaders and board members. We've got tonight Leanne Townsend and Leona Harvie. For more than 31 years, Leanne has helped people through some of the hardest legal and personal challenges of their lives. And she does it wearing three hats. She's an accredited divorce coach, a family lawyer, and a professor. Her career gives us a perspective most people in this space simply don't have. She spent 16 years as an assistant Crown attorney, including as domestic violence co-lead, prosecuting some of the toughest cases in the system. She then moved into family law for over 15 years as a partner at a Bay Street firm, as the founder of Townsend Family Law, and most recently as a senior divorce lawyer with Benmore Family Law Group. So when we talk tonight about high conflict situations, coercive control, and standing your ground in court, this is someone who has quite literally spent her career on her feet in front of these judges. Today, Leanne is winding down her legal practice and focusing on what she loves most, teaching and divorce coaching. Leanne teaches in the paralegal programs at Fanshawe and Durham College, hosts the Divorcing Well podcast, and co-hosts Divorce Explained, sits on the board of directors with DCAO, and offers divorce coaching services by helping people make informed decisions, reduce conflict, and move forward with confidence. Welcome, Leanne. Thank you for being here tonight.
Thank you.
Next up is Leona Harvie. Leona Harvie is a certified and accredited divorce coach and family law mediator, dedicated to supporting individuals through the practical and emotional complexities of separation and divorce. As the founder of Let's Talk Divorce Canada, Leona provides grounded, one-on-one guidance that helps clients navigate decisions with clarity, confidence, and stability. Her approach focuses on preparation, communication, and practical next steps, supporting individuals to move through transition with greater understanding and a clear path forward. Leona has long worked with many self-represented people such as yourselves and has been very involved in the National Self-Represented Litigants Project, the first school for self-represented litigants in Canada. Leona is also a board member and co-chair for the Public Awareness Committee for the DCAO. So thank you, Leona. Thank you both for being here. And I'm your moderator for tonight. My name is Thea Moreau. I'm also a divorce coach and board member with the DCAO. And with that, I'll turn it over to Leanne and Leona.
Well, thank you for the introduction, Thea, and we're definitely looking forward to doing the self-represented spouse workshop tonight on what is a very important topic, and I think a topic that comes up so often for self-represented spouses is understanding, not only the family law court system, but what emotion actually is and how it's different from other aspects of your family law matters, such as conferences or a trial. So we're going to kick it off. I'm going to be asking, some of the most commonly asked questions from self-represented spouses, to which Leanne is going to give her many years of expertise in the courtroom and as a family law lawyer. And I guess we'll start from there. How does that sound, Leanne?
That sounds fantastic.
Okay, great. So let's start off with understanding what emotion actually is and how is it different from a conference, such as a case conference, settlement conference, trial management conference, or a trial.
So emotion is something that a litigant wants to do or will do when they're seeking some form of interim relief. And as you know, the people on this call or in this meeting today may know, family court matters from beginning to end take a long time. They take sort of a minimum time might be 2 years if it goes to trial, and it can take years. So from when parties, first separate and family court proceedings begin to when there's an actual trial and conclusion can take a very long time. And during that period of time, often parties need to have some sort of interim order, interim relief, we call it, in place while the matter is still, going through the family court system. And so examples of things that you would bring a motion for could be interim child support. You need money to support your children while you're waiting for your matter to go to trial or while you're still trying to settle the matter. So interim child support, interim spousal support. Somebody might need spousal support. There can be things like exclusive possession of the matrimonial home if one party is seeking that. There could be a motion to have partition and sale of the matrimonial home. Maybe it makes sense to, sell the house because one party's living in it, one party isn't, and the party who isn't wants to, potentially get access to their money. The matter's going on for a long period of time. So that could be an example of an interim motion. There's all sorts of different interim relief that parties seek, but essentially that's what it's for. It's for something that you need in the shorter term while the proceeding is still going on. Whereas a trial is something that happens at the very end, and it's the point of the trial is to have a final order settling all of the issues. And then the conferences are they take place throughout the matter. There's various types of conferences: case conference, settlement conference, trial management conference. And these are mandatory steps in the process that the parties have to go through before they have a trial, but they have a different purpose. They're usually to try and settle issues and narrow issues, whereas a motion is where a party is actually seeking some form of specific relief or a specific order from a judge.
Okay, and that is really excellent information. Now, another question that comes up often is in Ontario, when can you bring a motion and do you have to attend a case conference first?
Yes. So, for the people on this call, they may or may not be familiar with it. We have something called the family law rules in Ontario. And if you are involved in a family law matter, the family law rules are kind of like the Bible of what you need to follow and be familiar with, particularly if you're involved in the court process. So the starting point for a motion is what is named Rule 14. Rule 14 governs motions and sets out all sorts of requirements and timelines and procedures and things like that. So Rule 14 sub 1 discusses when a party can bring a motion. And I'm just going to share my screen. I don't know how clearly I've got the rules here in front of me. How are people able to read that at all, or is it too small? Yeah. Okay. So as you can see right here at the top, when to bring a motion, and you can see Rule 14, a party who wants any of the following may make a motion, and it says a temporary order for a claim made in an application, directions on how to carry on the case, and then thirdly, a change in the temporary order. So that is when somebody can make a motion. But if you go down to Rule 14 sub 4, which is just down here, it very clearly says at the top, no motion before case conference on substantive issues completed. So the general rule of thumb is that parties cannot bring a motion until after they have had a case conference. A case conference is usually the first step in a court case where the parties and their lawyers, if they have them, meet with a judge. So generally speaking, you're not allowed to bring a motion until after you have had a case conference, and you get leave at the case conference to bring the motions that you want to bring. Now, there are some exceptions to this rule. And if I scroll down, you can see where it says urgency hardship, that sub-rule 4 does not apply if the court is of the opinion that there is a situation of urgency or hardship or the conference is not required for some other reason in the interest of justice. So in some very exceptional, extenuating circumstances, the parties can bring a motion before a case conference, but the norm is you have to wait until after the conference.
Okay, and how would you know if your issue is urgent enough for a motion versus something that can simply wait for the next conference?
So the rules regarding urgency are, fairly strict, because otherwise everyone would be trying to bring a motion before a case conference, and there'd be no point to having a rule that it needs to be after a case conference if the threshold for urgency was low. So generally speaking, it does really have to be something urgent. And examples of things that are urgent would be where somebody is, withholding children. So one parent isn't getting any parenting time at all. The other parent is completely denying any parenting time. So that would be an example where you could bring an urgent motion, and likely the court would agree it's urgent, and you could have some success. If you're concerned that a child, is about to be removed from the province or the country, that could be an example of urgency that would meet the limit. But disagreeing about whose weekend it is, that would not meet a requirement for urgency. Disagreeing about child support would likely not meet the threshold for urgency. It's a very high threshold.
Okay, and can you walk us through different styles of motions? Can you tell us the difference between a standard Form 14 motion versus a Form 14B motion? What the difference is between those two motions?
Yes. So a Form 14 motion is a motion that is basically there's substantive issues, and the parties are, generally not in agreement on them. So a 14B motion is what is referred to more as a procedural motion. So again, I'm just going to go back to share my screen again, and we can look at the rules. But a 14B motion is done in writing, and it's for procedural issues. So I'm going to just scroll down to Rule 14, 4.2. That's where it talks about the urgency. So with respect to a Rule 14 motion, you're going to file a Form 14, which is a notice of motion, and a Form 14A affidavit, which is the affidavit where the party sets out, the evidence that they're going to be relying on at the motion. And for a 14B motion, there's an actual 14B form that is used for that. And so for a 14B motion, for procedural matters, it could be something like the parties have agreed to vacate a court date, and so they're in agreement on it. It's a procedural issue. It could be something like the parties are in agreement about asking the court to appoint or involve the Office of the Children's Lawyer. So you could do that by way of a 14B. It's generally matters that are not highly in dispute. They're procedural in nature. They're uncomplicated. And it can be done in writing. All other types of issues require the Form 14 and the 14A affidavit, and usually, end up having to be argued either in person or virtually. And within the Form 14 and 14A, like the regular motion, you could have a long motion or a short motion as well. So that's two other types of motions within that. And so a short motion is something that can be argued within an hour, and a long motion is something that would take longer than an hour.
Okay, and I know when we speak to forms, when we say things like Form 14, Form 14B, Form 14A, This is a completely different world and a completely different language for self-represented litigants. Would you be able to explain which forms are needed and for what?
Yes. So for a regular motion, you're going to need a Form 14, which I'm going to show you what that looks like in a moment. A Form 14A, which is the affidavit. And you usually also do a draft order when you're bringing a motion. And we'll get into it probably a little more with a subsequent question, but there's also something called a confirmation, which is a 14C that you have to file. For a 14B motion, you're going to do the Form 14B, and you'll also do an affidavit with that. So just let me share what these forms look like so that people can actually see them. So this here, actually, let me just start with the Form 14. So Form 14 is a notice of motion. So you can see it's got the style of cause at the top, where the names of the parties are listed, and then down here it talks the court will hear a motion on, and you've got the date at the time or as soon as possible thereafter. This motion will be made by, and you put the name of the party who will be asking the court for an order for the items listed on page 2 of the notice. And on page 2, you're going to list the relief that you're seeking. So, if you're seeking an order for interim child support, that would be something that you list. If you're seeking an order for exclusive possession of the matrimonial home, you would be listing that there. And then it's signed by the parties, and this is served and filed with the court. So you can see this is what page 2 looks like. This is the place, this blank area here is where you state the orders that you're requesting the court to make on your motion. So with the Form 14, you also do the Form 14A affidavit, and this is what this document looks like. And again, you have your court file number, the court, the style of cause at the top. Then my name is, so whoever the party is that's swearing the affidavit, I live in, you're going to put your municipality and province. And then in this section here, in numbered paragraphs, you clearly set out the facts, which is the evidence that you are relying on for the relief that you're requesting in the notice of motion. So that is the Form 14A. And I thought I maybe had the 14B, but I don't think I pulled it up. So just let me pull it up here. So this is what the 14B looks like. Again, you've got the style of cause at the top, names of the parties, next scheduled court date, name of case management judge if there is one. You're going to tick off whether you're the applicant or respondent who's filing this. Then this section here, this motion is made. So sometimes it's made with the consent of everybody. So you tick off that box if that's the case, with notice, without notice. And then you're going to down lower why the court should make this order. So you're going to set out the reasons. You're going to set out the reasons for the order, and then up above here at the bottom of page 1, you set out the order that you want the court to make. So that's kind of similar to page 2 of the notice document, but you're setting that out here, and then the reasons for it. And then the law and rules that you're relying on go in here. And then you sign it or swear it. I should say sign it, and if you have a lawyer, but obviously the people that are attending this don't have a lawyer, so they're just going to sign it themselves at the bottom here.
Okay,
so that's what those documents look like.
Sorry, there's some questions here in the chat. Can we just touch on them first? Sorry. Okay. So we've got a question here that says, can a person still bring a motion when all issues are finalized?
So there's something called a motion to change. So if you have a final order and you want to change something in the order, then if it's 6 months have transpired since you have the final order, you could bring something called a motion to change. You could also, if there's enforcement issues, so for example, sometimes you have an order and the other party isn't complying with it, and so you're wanting to ask a court to take some sort of action to enforce it. So you can bring a motion for something like that. But if you have a final order, for example, for a parenting schedule, you can't just bring a motion to change the parenting schedule just because you don't like it. It has to meet the requirements for a motion to change or, some enforcement issue that you're looking for.
Okay, thank you for that. We have another question here. If you're not actively in family court, can a party self-rep and bring forth a motion to sell the matrimonial home? Just as a standalone motion, or are there other steps to go through?
I've seen it where somebody has brought a motion in civil court for partition and sale of the matrimonial home. But what usually happens when I've seen somebody try to do that, the judge in civil court will say that this is a family law matter, and if there's other family law issues, they will want them to all be heard together in the same place, and the family court is the correct place for that. So usually a civil court judge won't make a ruling on it, and they'll order that it be brought in family court along with, whatever other, issues need to be resolved. So it would be difficult to get a civil court judge just to make an order on partition and sale. And certainly I have not seen somebody successfully do that. I've always seen it ordered to go in family court along with the other issues.
Okay, great. And one more question. You can't bring a motion after a settlement conference, correct?
It depends. Sometimes you can. It depends on, I guess, if at the settlement conference, the judge writes on the endorsement or makes an order that no further motions are to be brought without leave of the court, for example, then you cannot unless you get leave of the court. Sometimes at settlement conferences, it's clear that it's still not ready to go to trial, quite frankly, and so you may still be able to get leave at a settlement conference to bring motions. So it really depends on what is said at the settlement conference. Generally speaking, by the time you're at a settlement conference, you shouldn't be in a position where you're having to bring motions for various things. But again, because in family law matters, with the passage of time, it takes so long for something to make its way through the system. Things unexpectedly can pop up or things can change that require a motion, and courts are reasonable about that sort of thing.
Okay, thank you, Leanne. That's the last question from the chat for now.
Okay, and going back to the affidavit, can you talk about how important the affidavit is in a motion and what sort of evidence you can attach to your affidavit?
Yeah, so affidavits are extremely important. Drafting a good affidavit is extremely important to success on your motion because generally speaking, when you go to court to argue a motion, there's multiple matters on the list. This is especially the case if it's a short, kind of routine motion. And in my experience, judges generally read the materials. You might get the odd situation where a judge hasn't read the material, but generally speaking, they're pretty good. They've read the material, and they don't, want you spending enormous amounts of time necessarily arguing the case in front of them. So they've read the material. They understand what's in your affidavit. And so for that reason, what's in it is very important. It's creating the first impression that the judge is making about your case when the judge is reading it. And it's the evidence. It's the evidence that you are relying on for the relief that you're requesting in the motion. So if the relief you're seeking isn't supported, you don't set out the evidentiary foundation in your affidavit to justify why you should get that relief, then you're not going to get the relief that you're seeking. So it's super, super important. But it's also important that you don't just throw everything, in the kitchen sink into your affidavit, hoping that, something sticks and the judge, something in there is what the judge wants to see. First off, there's usually page limits, and it's very important that when you're drafting your materials for a motion that you check the practice directions for the jurisdiction that you're bringing the motion in. And so, because every jurisdiction has practice directions, and these practice directions have page limits. So, as an example, I think in Toronto, the page limit for an affidavit for a motion is 12 pages. And then for the exhibits that accompany the affidavit is 10 pages. So you have 12 pages to put forth your best evidence. And so you want the things in there to be relevant. You don't want it to be repetitive. You don't want to keep making saying the same things over and over again. You don't want it to be inflammatory. Sometimes the facts of the case just are somewhat inflammatory, so you can't avoid that because you're just reciting facts. But, and you don't want it to be argumentative. That's really important. You want it to just be very factual, outlining what has transpired. And the more the merrier is not necessarily the right way to go either. I've seen cases where somebody's had every family member and friend that they have file an affidavit on their motion as well. So you have, 10 affidavits from a party's family and friends saying, what a great parent they are and how, they should be getting more parenting time or, things like that. Judges don't want that. They don't like that. Because first of all, they can see that it's your friend or your family member. So of course, what are they going to say about you? It doesn't mean that having one or two supporting affidavits like that wouldn't, help your case, but you just don't want to be excessive about it. You want to be reasonable. Judges have a lot of material to read through, and so they can get impatient if there's a lot of, repetitive things or unnecessary material that's filed in support of a motion.
So you touched on a lot of really, really useful points in the affidavit. And I guess from your perspective, because as a lawyer, you've probably gone up against self-represented litigants and seen their materials, what would you say are the most common mistakes that a self-represented spouse can make in their court materials or their affidavit materials?
So one common mistake I see is they exceed the page limits. I see lawyers doing that as well, quite frankly. But certainly I see represented people doing it. And if you do that, you do it at your own peril. So some judges will get very angry if a party has exceeded the page limits, and they will not read past the page limit. So if your most important evidence is on page 15 and you had a 12-page limitation, you could have a problem. In some cases, the judges still read it and they don't say anything. But that's a risk you're taking. And I don't think it's a risk anyone should want to take, that some of their most important evidence is not read by the judge. I think you should respect the page limit. So that's one error or a common mistake I see. The other one is just putting argument into their affidavit. It's argumentative. They're like arguing their case rather than just putting factual evidence in, because it's really just supposed to be facts and not argument. I see self-represented people sometimes putting in things that are just really not relevant. Like they're designed to make the other person look really bad, but they're not really relevant to the actual legal issues that are being argued on the motion. And so again, it's just important to really always, every paragraph you're putting in the affidavit, ask yourself, is this relevant to the relief that I'm seeking? And if the answer is no, then you want to question whether it needs to be in there. And then the other one is just what I touched on a little bit earlier, is just excessive affidavits, like affidavits from every person they know. And so they're filing, 9 affidavits for a motion, and you don't need that many affidavits to lay the foundation for the relief that you're seeking.
And when you speak to things that are relevant to what they're seeking in that motion versus irrelevant, One of the things I find sometimes with self-represented spouses is that they're not aware of what's relevant. It might be relevant to them because it's tied to an emotion or a feeling from their separation, but it might not be relevant in the motion. Can you give some examples of where you've seen things that are irrelevant inserted in there that although they do it assuming it's worthwhile in their materials, it can actually maybe backfire or frustrate the judge?
Yeah, I mean, I think that sometimes some of the arguments that parties have had with each other might not be relevant to a legal issue, or and so putting in, arguments, things that were said, that might not be relevant. I think that when you're wanting to lay a foundation for something, there could be things that might be relevant, but you need to pick like the five best examples of it. So if you're bringing a parenting motion and you have like 50 examples of why the other person, dropped the ball as a parent or did something wrong, like you don't need to put all 50 into your affidavit. Maybe pick the five most egregious examples and do that. And things like when parties are late for like a pickup or a drop off. Somebody being late once in a while is not really relevant to anything. We could all be late once in a while. Things happen. If somebody's consistently late and then that might be something that's reasonable to raise as a pattern of behavior that could support something. But you just don't want to raise like things that they were annoying to you, but they don't really pertain to a legal issue.
Okay, and Taya, I see that there is a question in the chat, which I think would be a nice segue.
Yes, there is another question here in the chat. Sophie asks, can a self-rep spouse use regular language, not using legal words like same, etc.?
Absolutely. In fact, I think judges prefer that. I think judges prefer when even lawyers aren't just using legalese, that we use what we call plain language. And I think it's great for you to do that. And I think, in my experience, judges prefer that. So definitely do that.
Okay, and going to the day of the motion itself, so talking about something that's in person, which would be a 14 motion. What can a self-represented spouse expect to happen on that day?
So, on the motion day, the motion itself, and you're going to know this in advance, it could be either virtual or in person. And, during COVID, that was when we started having these virtual motions. We never had them before COVID. And after COVID kind of ended, they carried on for a while, but the movement now in most jurisdictions, if not all, in my experience, is going back to in-person motions. So chances are, if you're bringing a motion these days, it's most likely going to be in person. So it's put on a motions list in front of a motions judge. So you go to court. There's going to be other matters on the list. Your matter is not likely to be the only one on the list. So there's going to be other parties there, other lawyers, a bunch of people. You want to get there early. I think it's, you don't want to arrive out of breath because you thought you were going to be late and you're rushing and your heart's pounding. You want to get there early so that things are as relaxed as possible and that you go into the courtroom feeling calm, and in control. And so court generally starts on time, not always, but court starts, the judge is called in. And usually in motions court, the judge starts by perusing the list. So the judge will go through each of the matters on the list to kind of canvass what's happening with each matter. Because some matters might be adjournments on consent. Some matters might have resolved. Some matters might not be proceeding. And then some matters are proceeding. So the judge wants to go through all of the matters on the list to assess what's happening with them so he or she can determine how long each one is going to take and then prioritize how it's going to go. Because generally, the short matters, so something that's just being adjourned, something that's happening on consent, those aren't going to take as long. So the judge will generally deal with those things first and then deal with the contested matters afterwards, and then prioritize those in terms of the level of urgency, and the complication of the issue, or how complicated the issues are. So the judge will peruse the list. You'll get an idea of when where your matter falls in, how things are going to go. You have to be prepared that you might be there all day. Don't think that because court's starting at 10 o'clock that you're going to be out of there by 11. You could possibly be there all day. So, book off your day at work. Don't make other commitments or plans because you need to be available if necessary. And when the judge finally does call your matter, the person who is bringing the motion, the moving party, is the person who gets to speak first, or if you're the responding party and the moving party has a lawyer, then their lawyer is speaking first. And it's important always to be polite and respectful to the judge, even if you don't like what the judge is saying. Generally, arguing with judges doesn't get you anywhere. At the end of the day, they get to decide what's happening, right or wrong. And if they're wrong, you can appeal. There's remedies for that, but being rude or disrespectful is not going to get you anywhere. And it's important, particularly in Zoom, this was important, but I think it's important even in real court, be mindful to just appear, calm, unfazed, and really emotionless. Like, don't roll your eyes, don't make weird facial expressions or angry facial expressions. As I say, it's always bad in Zoom court because, you just have everyone's head there. So when someone is doing some of those things, it's really obvious. But you don't want to do that because it's not going to impress the judge. It doesn't make you look good, and it makes it look like your emotions are controlling you and you're not going to be a reasonable person here. So no matter what the judge is saying and how much it's driving you crazy in your head, what they're saying, don't react to it. And I think just in terms of managing, I always say this to my clients, so I would say it to a self-represented person. Going in, have the expectation that the other side, and their lawyer, if they are represented, is going to say things that upset you. They're going to say things that you may say are not even true. The lawyer's relying on what their client is telling them. And you're going to sit there and you're going to have to listen to either the other party or the other lawyer saying things that upset you and that you may say are not even true. And that's going to happen, and you will have an opportunity to speak and an opportunity to address that, but don't interrupt, don't react when it's being said. Again, just be calm, keep a poker face, and then when it's your turn to speak, you can address anything that's been said that is incorrect.
Okay, and that's really, really good advice, because the one thing that I do hear from self-represented litigants is that it's very triggering when the other side, whether they're self-represented too or with counsel, is saying things that are untrue. So you're essentially saying, don't take the bait, stay calm, stay level-headed, stay collected.
Absolutely. It's so important.
So important. Are there any tips that you would recommend self-represented spouses do when they're up against a lawyer and feeling that power imbalance?
I think it's important to remember that there's lots of self-represented litigants who do very well in court. Like, yes, it can be intimidating, but don't let the other lawyer intimidate you. You are there, and if you're prepared properly, which I strongly urge everybody to be, then it should be a level playing field. And don't let the other lawyer intimidate you. You know what you're there to argue, you know what you're there to say, and make sure that you stick to what your plan is. I mean, obviously, if something unexpected arises that you need to address, you're going to need to address that. But there's lots of cases where self-represented people have done very well. And in fact, there's like a very recent one that's well known to do with intimate partner violence, and it's the Ahluwalia case, which it went all the way to the Supreme Court of Canada, and there were lawyers at that point. But this is a case that started with a self-represented woman at the trial stage who ended up creating new law in Canada by creating a tort for domestic violence, essentially. And that, as they say, and she got damages for the abuse that she had endured, and she was self-represented. So just because you're representing yourself doesn't mean that you won't succeed, and that you might not. You may even make new case law and have a precedent-setting case. It's all possible.
Which would be an amazing goal to set as a self-represented litigant, and one that you're
Absolutely.
saying, and we have this wonderful example to show that it is achievable.
We
Okay,
have a couple
so,
more questions.
oh, you
Can
have
we
another
discuss
question?
on these?
Okay.
Yeah. We have one from Mel. You mentioned before that in finalized cases, a party cannot file a motion to change parenting time simply because they don't like it. But there are criteria to do so. What are examples of cases where a Toronto court would allow such?
So, if you want to bring a motion to change, there has to be a material change in circumstances. So, if the parenting schedule was it de facto change, like so if the parties weren't following it, so you wanted to bring a motion to change to have the order reflect what the actual schedule is. If another example could be a party develops some sort of problem like either a mental health issue or a substance abuse issue. And so what the final order says is now problematic because they've got a problem, and that needs to be addressed for this health and safety of the child. Those are things. I think the question was to do with parenting issues, right? Like not like obviously with support and things like that, people's income can change, and that can form the basis of a motion to change. But or if a child's like not doing well, you have a schedule, you're following it, and you've, followed it for 6 months, and a child is, not their school, their academic record has declined in school, their mental health has declined, there's issues happening, anything like that could form the basis for bringing a motion to change. The courts are very, very focused on the best interests of the child. So, anything that shows that a child is not doing well as a result of a court order, a court is going to be open to looking at, a motion to change. If it can be shown that, again, that a child is doing poorly or not thriving as a result of a regime that was ordered in a final order.
And some other things I've seen, and correct me if I'm wrong, but if like one parent is not available, if they've had a change, if they're traveling more, if the
Yeah.
child's being left with third parties.
Yeah.
And then sometimes children get to an age where they themselves start to express a change.
Yeah, absolutely. Those are all things, and especially the last one you mentioned there, Leona, is really important. That as children get older, they do have more of a voice in the parenting schedule. So sometimes what a judge deemed to be an appropriate schedule in their best interests when they made a final order is the child gets a little bit older. Maybe they were 9 when the order was made, and now they're 12, and the child is very vocal about what they want and why, and that can be very relevant and very helpful information in bringing a motion to change and changing a schedule that's not working.
And that's all great feedback. Taya, I saw some more questions in the
Yeah.
chat. Would you like to?
Yes. So another question we have is if you are the self-rep spouse being served a motion, sale of the matrimonial home, when do you get to see a copy of the motion and do you get to respond to their 14A? Only have been told if there is a date set.
Yes, so the family law rules deal with timelines for serving materials and filing them with the court. And so when somebody is bringing a motion, they have to serve the documents no later than 6 days before the motion date. That's for like a standard short motion. So um, you can they can serve you like up, they can sit on it, I guess, up until 6 days before. But they have to serve you at least 6 days before. And then you have an opportunity to file your responding material, and that has to be done 4 days before. So it's a tight turnaround time, unfortunately. And, often if you have a motion date that's set way out, it's reasonable for the parties to confer on a timeline for the materials so that you're not in the situation of the 6 days and the 4 days that's in the rules, and you have more time. But if you can't agree on something like that, those are sort of the minimum amount of time that's required. And so, I know even as a lawyer, when I get served with a motion, sometimes you are scrambling, trying to prepare a response. If you have an idea of what the motion's for, then you can kind of start preparing your response in advance, even without their material. And then obviously once you are served with their material, you can adjust it accordingly, but you can start kind of building your case and your response, beforehand, because you probably have some idea of what the issues are and what you need to address.
Okay. And from the same person, we have a question. Do courts consider adult dependent children's well-being as well? And she had another question. Does the OC have to communicate with a self-rep spouse?
So the courts definitely consider adult children's well-being. It depends again on the situation. So um, adult children don't generally have a parenting schedule, so courts are not, generally ordering parenting schedules for 20-year-olds and, things like that. They do order child support, though, for adult children if they're not able to, self-support, if they're still in school, for sure. But if they are done school and they're just not able to become self-supporting, or if they have special needs or a disability or a handicap, then, absolutely. Courts will order child support in those types of situations. Sorry, what was the second part of the question?
Does the OC have to communicate with a self-rep spouse?
And for anyone who doesn't know, OC stands for opposing counsel, so the other side's lawyer.
Yes, and they do. They absolutely have to. And they generally will probably want to communicate with a self-represented person in writing so that there's a record of what's being said. A lawyer who communicates verbally with a self-represented person sometimes is putting themselves in a precarious position, because if the self-rep decides to say they said or did something that they didn't say or do, they don't have a record of it, and that could open them up to some problems. So generally lawyers prefer to communicate in writing. Or you could record it. I mean, I have had situations where I have met with a self-represented person and to have settlement discussions, because it was the only way we could do it. And it was in my client's interest to do it. So we did it on Zoom and we recorded it. So I had a recording of it. So that's another way around it. I can see a follow-up question to any remedy if they're not communicating, they booked the motion date without my knowledge. So if they're not communicating, that's something you definitely want to, when you get in front of a judge, you should definitely raise that with a judge, because that's not a good look for a lawyer to not be communicating with you. Parties have an obligation to confer before a motion. And as well with booking the motion date without your knowledge, like that in some ways could be considered sharp practice. Like generally it's professional, it's considered to be professional courtesy to canvass motion dates with the other lawyer or the other party before booking it. And I know certainly if I'm dealing with a situation where the other party is a self-represented person, I will obtain motion dates. I will send them to the other party and ask them their availability, and try to get a date that works for both sides. Now, there are situations where parties just, no matter what date you say, they say they're not available. And so you try to confer on dates, and they just said they're not available, not available. And so in that type of situation, then, you may just go ahead and book a date. And they'll have to try and argue for an adjournment if that's what they want to do. But generally just going and booking a date without even asking the other side at all, that kind of borders on sharp practice and is frowned upon by the courts.
Okay, and in terms of when you're actually in the motion, can it be assumed that the judge has read all of your materials? And if the answer is no, how do you suggest that the self-represented spouse effectively present their materials?
Yeah, that's a difficult one because, in my experience, most of the time the judges have read the material, but I have had situations where I felt like the judge didn't read the material, unfortunately. And I've had situations where, the judge doesn't say that they didn't read the material, so they're acting like they did, but you can tell that they did not. And so I think you have to kind of it's one of those things where I think you have to gauge it as you're going along because you can tell when you're in court whether the judge has read the material or not. And so, if it's clear that they've read it and the way that they're responding to things and they're on top of it, you don't need to be taking them through everything A, B, C, D, E, F, G. But if you have any concern about it, then you should. You should start with the assumption that they haven't read the material and that the most important points are to you may not be things that they've noted or grasped onto. And so you should make sure that you highlight them. And if there's particular things in your affidavit that you want to absolutely make sure the judge is aware of, then you should definitely draw the judge's attention to those. So you're better off to assume that they're not familiar with the material. And then if they kind of shut you down and push you around, saying they have read it and they know that, then you might have to adjust a little bit, but you're better off to assume nothing and try and make sure that all the points you want heard are made and heard.
And that's a really great tip because I've heard the same thing as you, where some people say they go to court and they're unsure if the judge has actually read the materials. So the motion has happened and the judge has given an endorsement, there's an outcome. Can a self-represented spouse be ordered to pay the other side's legal costs if they were not the successful party at the motion, and how does that work?
Yes, absolutely, they can. So costs are governed by Rule 24 in the Family Law Rules, and Rule 24, subsection 3 states that there's a presumption that a successful party is entitled to costs. So it's actually encoded in the Family Law Rules, Rule 24, subsection 3, that there's a presumption that a successful party will be entitled to costs. So if you're successful, you can be entitled to costs. Now, obviously, it's different if you don't have a lawyer that you're paying. What your costs are might be different, but I mean, it doesn't mean that you don't have costs. You might have taken off work that they're arguing the motion. There might have been costs in, the materials. You might have used a lawyer to prepare the materials, but you're there arguing it yourself. So there could still be legal costs, but you're absolutely entitled to them. And Rule 24 sets out like a number of situations with respect to costs. So if the success is divided, for example, meaning that you get some of the things you wanted and the other side gets some of the things they wanted. Rule 24 sub 4 addresses, how the court can apportion costs between the parties. And if you are successful, even though there's this presumption that a successful party is entitled to costs, if you behaved unreasonably, Rule 24, subsection 7 says that you can be deprived of some or all of your costs for unreasonable behavior. And Rule 24, sub 8 sets out some of the things that the court will look at in assessing a party's behavior. And it includes, your behavior in relation to the issues from the time that the issue arose to the time of the motion. Court will look at whether you made an offer to settle, whether the other side made an offer to settle. Was the offer to settle reasonable? Was it withdrawn? Was it what, all of that sort of thing. And so offers to settle are also extremely important when you're bringing a motion. I highly, highly recommend that a party make an offer to settle before a motion, because that could help you on the issue of costs. And so it could give you some protection there. But costs are like can be a very big issue on a motion. And if you lose and the other side does have a lawyer, I mean, I've seen people have to pay $20,000, $25,000 on a motion for the other party's legal costs. So, and the reason for that is that courts want to discourage people from bringing frivolous or unnecessary motions, so that there is a very real consequence to bringing it and to losing.
That's really useful information. I'm just looking at the time here, and we have 4 minutes left.
And
So
we have
I
another
wanted.
question.
Oh, is there another one? Okay.
Yeah. Yes. So this person says, I've been told that a motion for sale of matrimonial home always wins. Has that been your experience?
I mean, every case is going to be fact specific. So I would never want to provide an opinion on whether something is always successful or not, because in my experience as a lawyer, there's no hard and fast rules about somebody always winning. Having said that, though, when on a motion for if parties own a home jointly, you are well positioned to be successful on a motion for purchase and sale of the matrimonial home. There are exceptions. Courts will, sometimes. In fact, I know of a case recently where the wife was living in the home with the children, and it was a very abusive relationship, and the court ordered that the home should not be sold at this time because of the what it was going to do to the wife and the children to have to move in light of all the abuse that the wife had suffered. So it is possible to succeed against a motion for partition and sale, but generally, and again, I'm just generally speaking, it's a motion where you have a pretty high rate of success if you're bringing it and there's not abuse. Both parties jointly own it, and it has a high rate of success.
Okay. And is that all of the questions in the chat?
That is all the questions in the chat, and I
Okay.
just have a couple really quick slides to share. I think we're going to have to wrap up just because we do have only 2 more minutes. I'm going to share my screen. As we mentioned before, DCAO is a collection of divorce coaches and affiliated members such as lawyers and mediators, legal professionals of all sorts, and also things like realtors, anybody that touches divorce in some way. We do have members in all those categories. And you can find them if you're looking for somebody to work with at DCAO.ca, and you can click up here on membership directory, and then it'll take you to all of our members. Or you can, if you're also looking for somebody, you can also just email info@dcao.ca. We have a number of events coming up, and we just thought we'd highlight it here. The first of which we're mentioning here, the DCAO Divorce Summit. That's coming up in September, on September 15th from 11 to 1. It'll be 4 topics, so half an hour for each topic. And those are all listed here. It's not on our website yet. It is a newer event, but it will be up this week. And at the end of this summit, people will have a chance to sign up for Discovery Call with the Divorce Coach. We also have more of these types of workshops coming up. One on Tuesday, October 6th at 12 p.m. On strategies to win in family court and collect costs. And then another one in November, how to calculate equalization payment and settle the matrimonial home. So those are our events right now. As I mentioned, they will be on our website. These 2 already are. And
we also have the DCAO film night on
as well,
September 28th as well.
Here. That's right. We have a film night on intimate partner violence coming up did you just say it was the 28th, September 28th?
Yes, September
That's
28th at 6
okay,
p.m.
at 6 p.m.
Yeah.
That you can find on our website as well. And that's all we've got for tonight. I'll stop sharing. Does anyone have any more questions before we sign off? We're at 6:31 here. Sorry. Okay, we have a lot of thank yous. Thank you all for joining us. We really appreciate you being here.
Yes, thank you, everybody.
Thank you. Have a good night.